Assalamualaikum and hi everyone. Let us start with the recitation of Al-Fatiha. Okay, my apology for this late recording. I'm not very well and currently pun still tak recover 100% recovering. But okay, this is the recording for the continuation of the class on the qualification for copyright protection. Okay, this is actually provided under section 10. So there are four factors. There are four factors in order for a work to be protected in Malaysia. First is the status of author, place of publication, work made in Malaysia, and these three factors are provided under section 10, while this one, government copyright, is provided under section 11 of the Copyright Act. Okay, first is the status of author. Section 10, subsection 1 provides that copyright shall subsist in every work eligible for copyright of which the author or in the work. In the case of a work of joint authorship, any of the authors at the time when the work is made a qualified person. Meaning to say that in order for a work to be protected in Malaysia, that particular person or that particular author must be a qualified person. So who is this qualified person? The qualified person, the definition of a qualified person being defined under section 3 in which section 3 mentions that in relation to an individual, okay, in relation to an individual means a person who is citizen or a PR of Malaysia, and if that particular qualified person was a body corporate, then that means that the body corporate established in Malaysia. Okay. For the first factor, in order for a work to be protected in Malaysia, Section 10, subsection 1 provides that that particular author must be a qualified person. So who is this qualified person? Section 3 define qualified person. If it is involved individual, it must be a citizen or PR of Malaysia, or if it is in relation to a body corporate, then that particular body corporate is established under the law of Malaysia. Okay, so that is the provision provided under section 10 of the Copyright Act. However, the Malaysia also, since Malaysia is one of the burn countries, one of the signatories of the burn country, so there is the effect of the copyright application to other countries resolution 1990s. Okay, aside from the Copyright Act 1987, copyright also is governed under copyright application to other countries regulations 1990. So what is the effect of this copyright regulation? Okay, for the literary, musical, artistic works and film, regulation 3 subsection paragraph E of the copyright application to other country regulation mentions that if that particular citizen was a if that particular author was a citizen or resident of a Berne Convention country, then he or she is also considered as qualified person. Or if it is a body corporate established under the law of any Berne Convention country, then that particular body corporate is also considered as a qualified person. Okay, so just now I mentioned that under section 10 of the Copyright Act, section 10 subsection 1 of the Copyright Act mentions that in order for a work to be protected in Malaysia, the author must be a qualified person. So the qualified person is a citizen or PR of Malaysia or a body corporate established in Malaysia. Okay, that one is due to the Copyright Act 1987. However, Malaysia also has another statutes governing copyright in Malaysia, which is copyright application to other countries regulation, in which this copyright application to other countries, this regulation extend the definition of the qualified person just now. Say, in which qualified person, if it is involved literary, musical, artistic work and film, If that particular person is a citizen or resident of Bern Convention, then he or she is also considered as qualified person. Okay, for example, Ame is a citizen of Singapore. Okay, if we rely on under section 10, then Ame cannot register his copyright in Malaysia. However, since Singapore is a Bern Convention country, then Ame can register his work in Malaysia because due to regulation 3E of the citizen or resident regulation 3E of the copyright application to other country regulation. Okay, that one if it is involved literary, musical, artistic work and film. Okay, second is about the sound recording and broadcasting. If it is a sound recording and broadcasting, regulation 4 subsection 1 paragraph E mentions that if the author was a citizen or resident of WTO country, then he or she is also considered as qualified person. WTO stands for World Trade Organization country. So if it is involved sound recording, then that work can also be protected. It's considered as protection in Malaysia. Okay, and regulation 4 paragraph 1 subsection E read together with schedule 3 of the regulation mentions that for a published edition, if a publisher is qualified person, then he is considered as qualified person if he is a citizen or resident of UK, or if that particular body corporate is established under the law of UK, then the publisher is also can be considered as qualified person. Alright, okay, that is factor 1, okay, for the status of author. Factor 2 is on the place of publication. Section 10, subsection 2 mentions that copyright shall also subsist in every work which is eligible for copyright if that particular work is first published in Malaysia. For example, you Hafiz. Okay, for example, Hafiz create this film, and then this film was first published in Malaysia. So that Malaysia is the place of publication. Okay. If it is involved a work of architecture is erected in Malaysia, or being any other artistic work is incorporated in a building located in Malaysia, or a broadcasting transmitted from Malaysia, as long as that particular work comes from Malaysia, then the place of publication, the work can be protected in Malaysia. Alright, so what is the differences between publication and first publish? Okay, publication. Section 4, this is quite a lengthy explanation on the publication. Section 4, subsection 1 provides that for a literary, musical or artistic work, or an edition of such work, it shall be deemed to have been published only if a copy or copies of the work have been made available with the consent of the author, in a manner that satisfy the reasonable requirement. Okay, so if this is involved literary, musical or artistic work, as long as you have already made a copy or copies to the public with the consent of the public, and you have already satisfied the reasonable requirement, then it is considered as has already been published. Okay, for a film, if that particular film has already been sold, let on hire or offered or exposed for sale or hire, so letting on hire or offered of hiring that particular film also can be considered as reasonable requirement for the publication. And for the sound recording, if it is being made available to the public. Okay, so there is a lot of reasonable requirement. This here is the reasonable requirement. So what is this reasonable requirement actually? Okay, so in the case of television broadcast limited and others, and Mandarin Video Holdings and John Berhad, the court defined that the release for sale of 6 copies of a song was sufficient sufficient to be what? Sufficient to satisfy reasonable requirement. The requirement was met as long as the copies reach the dealers. Meaning to say that it does not necessarily means that in order for a work to be published or to be said has already been published, you have to satisfy perhaps 1,000, 2,000 copies of the song, or 2,000 films has been letting on hire. No, it does not necessarily like that, because according to this case, as long as you have released for sale 6 copies of a song, it is already sufficient to satisfy the reasonable requirement for publication. Okay, so that is for the reasonable requirement. Okay, what about the consent of the author? So section 10 subsection 1 section 10 subsection 2 just now mentions that a film is considered as already be published if first, if it met with the reasonable requirement. Second, if it get the consent of the author. So what about the consent of the author? So you can see in these two cases, in Asia Television Limited and another, and Viva Video Center Berhad, what happened in this case is that appellant claims, okay, this is an appeal case. So if it is appeal case, then the parties in the case will be appellant and respondent. So appellant in this case claims copyright. He claims copyright in some of their Hong Kong film, but in order for that particular film to be protected under copyright, it must be published in Malaysia. So the copyright is contended in Malaysia. However, respondent mentions that, okay, no, appellant cannot get appellant is not the author, or appellant cannot get the copyright protection in Malaysia because appellant failed to pass the Film Censorship Act. Okay, since the appellant failed to get the certificate from the Film Censorship Act, then appellant could not get the protection in Malaysia. However, the court decided otherwise. Court mentions that no, even though the appellant is in breach of other law, it doesn't mean that his rights under the copyright is limited or is prohibited. So meaning to say that even though the appellant failed to get the certificates from the Film Censorship Board, he still is able to get his rights in Malaysia protected. Okay, that one is for the Asia Television Limited case. Okay, next is the case of MediaCorp News Private Limited and Mediabank Sdn Bhd. Okay, what happened in this case? MediaCorp is actually a company in Singapore and Mediabank is a company in Johor. Okay, what happened is that it is a broadcasting company. Plaintiff MediaCorp here, they sue Mediabank due to the infringement of the recording of its broadcast of its product that has already been broadcasted in Singapore. So he claims that MediaCorp claims that Mediabank has already infringed their rights. Mediabank say no, you cannot claim the copyright because you are not from Malaysia. But court said that you cannot say that because Singapore is one of the WTO countries, so it is entitled for the copyright protection in Malaysia. Okay, next is for the first publication, section 4, subsection 3 mentions that for the purposes of this act, a publication shall be deemed to be a first publication in Malaysia if it is first published in Malaysia or the work was first published elsewhere, but within 30 days, such publication was made in Malaysia. Meaning to say that you have already published it elsewhere, but within 30 days of the date of publication, you come and publish it in Malaysia, so it is considered as first publication in Malaysia. Alright, so this is the type of the copyright application to Agricultural Regulation 1990. Okay, if that particular work was published in any of the UN Convention countries, then that particular work is also considered as first publication in Malaysia. For example, if I refer to this case, Haji Ken Konsu Abu Sisi Faisal and allied suspect motors in Tambahan and another. What happened in this case is that on the second, plaintiff is the owner of the towing of a 2D and 3D towing of a motorcycle, in which that particular towing has already been created in Japan, but it was first published in Thailand. And since Thailand is the Berne Convention country, then it is considered as first publication in Malaysia. Okay, in another case, Abu India Limited and Abu Disma Berhad, what happened in this case is that Abu India is the manufacturer of product toothpaste products from and swap from India. That particular work has already been published in India, and since India is the Berne Convention country, so it is considered as first publication in Malaysia. Okay, so that is for the literary, musical, artistic work and film. Now we're moving to the sound recording and broadcast. English is the work involved in sound recording and broadcasting. If that particular work was published in any of the WTO countries, then the work is considered as first publication in Malaysia. Can refer to these two pages for record and Citizen Karaoke and MediaCorp News Private Limited and Media Bank JB Samprahat. Okay, took MediaCorp News Private Limited, just like what I have explained just now. Since Singapore, this is a company in Singapore and Media Bank is a company in KB. So MediaCorp claimed that Media Bank has already infringed their copyright, but Media Bank claimed that no, you cannot say so, because in order for you to get rights to be published in Malaysia, you must first obtain some sort of license. But the court said that since Singapore is a WTO country, so MediaCorp is entitled for the copyright protection in Malaysia. Third is the work made in Malaysia. In section 10, subsection 3, mentions that notwithstanding subsection 1 and 2, copyright shall subsist and get exercised in every work eligible for copyright if the work is made in Malaysia. Meaning to say that even though that particular person is not the author, if status of author is not from Malaysia or any of the Berne country or WTO country, or the work is not published in Malaysia, as long as the work is made in Malaysia, then the work is eligible for copyright protection in Malaysia. Okay, you can refer to this case Hexagon Towers number Berhad, in which the court held that the drawing was completed in 1995. The word made denoted the time when the drawing was actually completed. So since the word made here refer to the time when the drawing was completed and the drawing was completed in Malaysia, then the word can be completed in Malaysia. Alright, and lastly is the government copyright. So this government copyright is actually provided under section 11, in which it mentions that copyright shall subsist in every work which is eligible for copyright and which is made by or under the direction or control of the government and such government organization or international body as the minister may by pre-order prescribed. Here, section 10 shall not be taken to confer copyright on works to which this section applies. So, meaning to say that here, if the work is, if that particular work is under the direction of the government, or for example, even though you are not a Malaysian, or even though the work is not made in Malaysia, but since if it is under the government of Malaysia's direction, then the work can be protected in Malaysia. That's what section 11 is all about. Okay, now moving to the work eligible for copyright. Okay, to summarize, there are 4 factors. In order for a work to be protected in Malaysia, there are 4 factors. First is the status of author. Author must be a qualified person. Section 10, subsection 1 mentioned that author must be a qualified person. And who is this qualified person? This qualified person shall means that the person is a person of citizen or resident of Malaysia, or if it is a body corporate, then it is a body corporate established in Malaysia. Okay, but by the extension of the copyright regulation, even though you are not a citizen or body corporate established in Malaysia if you are a citizen of a burn country, or the body corporate established under the burn country, or also WTO country, or as well as the publisher established under the law of UK, then you are also eligible for copyright protection in Malaysia. Okay, that one is for the status of author. Second is that that particular work must be published in Malaysia, in which this one also there is exception to this. There is extension to this, in which if the work is first published in any of the Berne Convention country, then it is also considered as first publication in Malaysia. Taking into example case Kabushiki, Honda Chicken Kogyo, as well as Dabu Nagasaki. Okay, now third is the word must be made in Malaysia. Okay, word made in Malaysia here means that if the work is made in Malaysia, not considering that you are not the author residing in Malaysia, or you are not from any of the burn country, or if it is not first published in Malaysia, as long as it is made in Malaysia, then it is eligible for copyright protection in Malaysia. And last one ialah government copyright. So this one also is eligible for copyright protection in Malaysia, as long as it is made under the direction of the government of Malaysia. Right, I think that's all for the factors for a work to be protected in Malaysia. Since this is a recording, I don't want to make it very long. I will continue this in our next class for the works eligible for copyright. Right. So with that, I end my recording with the Dasbah Kafarah and something else.